Last year, we should have had with us Emanuele Lauro, who had a problem with seagulls his flight, and I hope we can have him next year. But we have two very important figures on his chess table. And one of them is speaking in this panel is Luca Forgione. Luca has got an amazing experience because he's studied at University of Genoa, which is an extremely good university also for shipping matter, is specialized. And Southampton has been a tutor at UCL that also had among its students even myself. And since 2009, he is one of these amazing people who have are now controlling more than 250 vessels, the majority of which owned, and they are in their 30s or late 30s. And so they are changing the world of shipping, in my opinion, for the best. It's not everybody's opinion. Obviously, the facts will show this. So I think having the some sort of, I hope perhaps next year you'll give us a speech, but this year I think you wanted to sound the floor, and I would very much like to hear your appreciation or comments on this session, and if you have any question or idea to be put, because I think you are both on as also some other panelists of this session, on the legal but also on the commercial and corporate side.
Well, thank you very much for such introduction. Now you put me on the spot and I shall have to say something. But obviously we have been speaking about the law for the last one and a half hours, 1 hour. I know time flew. And I know we're late, so I shall keep it very short. And, those who actually are speaking are much brighter and much more experienced, so I really wouldn't be able to say much. But what I did find interesting, and I always find it interesting, is probably the matter of interpretation of contracts, because it is really where the law, the logic, the words, so the English language, the command of English language, and therefore the misuse of English language by people like me, who obviously are not mother tongue, is where it all comes together. And it's funny because you read cases and you start and you think, okay, company A is absolutely right, and then you read the defense submissions. No, hang on a minute, company B is absolutely right. And reaching a conclusion is very, very difficult. And if I can use the elements given by the panel today, I would put two and two together. We have one case where Ian has successfully defended, well, actually Marco, but together with Ian, successfully defended the client against the big and nasty trafigura, which we all like anyway. And if you look at the clause, and I don't have it, well, I probably have it with me, but it reads clearly, in addition to any other rights that charters may have, blah, 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 owners will be responsible for the full amount of any in-transit loss, full stop. If you stop there, which we could, any in-transit loss means just that. And if we go back to the old school approach, a word says exactly what it means to say, or it's supposed to be saying, nothing more, nothing less. So if you take that strict approach, then Trafi maybe was not entirely wrong. Again, I'm simplifying greatly, and contract has to be seen in its entirety. So there are many arguments, and I haven't read the 100 plus probably pages. But it's interesting because we always need to take a position, and it's difficult for us with our internal clients who are not legally trained to explain. They think they have a better, a good case, and then sometimes they are surprised because they read it, and they may or may not be English, they may or may not be legally trained, more often than not they are not. And but this is what I meant, and you need to explain, well, what you meant doesn't really matter if it wasn't clear. And of course we take part of the blame if we have vetted the contract and didn't see the problem coming. But you never quite know, because to answer one of the questions with which we started the discussion, where do I stand on whether or not the payment of hire is a condition? Well, easy answer is depending on what client I'm advising. Obviously, as owners, we're very happy with the decision. We could be happy, but what I'm saying is, in this business, we are both owners and charters, as much as we, in trading, you are seller and buyer. So it's difficult. Whatever is good for you today may not be good for you tomorrow. So I like the academic challenge and the thinking behind the case, but then when it comes down to deciding, it's really difficult to decide for good. And though, if you do that, and the court will decide one way or the other, what we will have will be certainty, which is really the only thing that we need. Whether we like it or not, if that's the law, certainly we cannot live with two cases that say exactly the opposite, because our life is very difficult in trying, again, to advise the client as much as yours. And so certainty is very much welcome, and I look forward to June, and maybe we'll have a conversation. And that is really it, because if not, we'll talk for hours. Unless you want to
thank you.
Cross-examine me or something.
And I was going to extend it to the other panelists. I think, is it Manuela Bottiglieri, if I pronounce your name correctly? I'm particularly interested in what Jonathan Lux was saying about mediation and arbitration. And if you have other comments, obviously we'd be interested. But in your work, do you get involved in mediation or arbitration? Are you in favor of one or the other, or
Good
none of them?
evening to everybody, first of all, and thank you, Francesco, for inviting me as panelist in this wonderful location. I have a question for Mr. Lux. Do you believe that maybe it's a good opportunity to include inside the charter party a clause where the mediation has to be considered as a first method of alternative dispute resolution before to go to the court, or maybe this is against the right to go to the court proceedings? Because, for example, sometimes we have the clause to go to LMA, London Arbitrator Association, of course, but maybe it is possible to have, before to arbitration or court proceedings, to start a mediation. I was involved already in 2 years ago in a mediation, and I think that it's very nice opportunity, not only because then after the two parties, counterparties, are good remain in a very good relationship at the end. And also, of course, because P&I Club, of course, knows the cost of mediation is very low if we have to compare to London arbitration or English court proceedings. Thanks.
Thank you for that. So the question is it a good idea to have a mediation
clause
as a precondition to
Yes.
arbitrating or court?
Yes.
I think there are some traps there for the unwary, because it follows that the arbitrator, if someone ignores the clause and simply starts court proceedings or starts arbitration, that would go to the jurisdiction of the tribunal. And if there is a time limit that's coming up, then you could end up being time barred because you've missed the fact that that precondition needs to be complied with. So as I hope I indicated, my preference, instead of having a rather rigid multi-tier dispute resolution clause which operates sequentially, is either to rely on what I was suggesting and apply to the arbitrators when you're ready to, excuse me, when you're ready to mediate, or actually amend the arbitration clause in the Charter so as to make express what I've suggested. In other words, that the arbitrators, in case they don't have the power I'm suggesting, that the arbitrators shall have the power to order a stay and to make an adverse costs order if one party refuses. I prepared an article which goes into all of this in some depth, and if you're interested in receiving that, if you email me or give me your card, then I'll be happy to send that to you.
Thank you.
Thank you. Do you have a follow-up on that? Otherwise, I would like to ask Mr. Is it Nygård? Mr. Nygård, equally questions about mediation and arbitration within the club. Is that something that you have experience of and that you are in favor of or not?
Yes, within our club, we first of all have arbitration clauses in all our policies, so we are very familiar with that institute. And personally, I'm very much in favor of arbitration. Nice to hear Mr. Luck's speech here today, and I'm pleased that somebody else than Stephen Ruttle appeared on the scene, because I think my first 5 or 6 times I was invited to mediation, the same mediator appeared. And to me, it was a question whether he was the only one who did mediation in London for a period. So I'm welcome to see a broader panel of mediators appearing. My personal experience, I cannot beat the track record of 90% success in mediations. Certainly not on the day of the mediation. But my experience is that the mediation itself, in many ways, is instrumental to get an amicable settlement, maybe in the time after the mediation have appeared. So you, by that, can avoid the case costs, the expensive case cost of having to run through the full proceedings. And yes, we see not only in London, but in other places of the world, that mediation becomes more and more common. And in general terms, I'm very, very favorable of mediation as a dispute resolution mechanism.
Can I just add to that something that I was involved in, which I have never come across myself at all, and that is we talk about mediation and arbitration or court proceedings, but they are not mutually exclusive. So there was an arbitration for, I think, 4 weeks and a big insurance claim, it's a marine claim, but an insurance claim in January of next year, in 2016. I think that was going to cost the parties something like £2 million on both sides. It was a huge claim. But the parties decided to try to mediate the claim about a month ago. So they appointed a mediator whilst the arbitration was still continuing. And then I was appointed to do a legal evaluation of the issues, non-binding, with the mediator sitting in. So I had a one-day hearing on a Wednesday when I would hear the arguments on both sides and produce a very short, it was a 5-page, non-binding assessment with the mediator present, and then the mediation took place the next day, and the case settled. I think it was a $100 million claim. The case settled before the weekend. The only people who were very upset were the lawyers who were involved in the 3 or 4 week arbitration in January, and I have a lot of enemies in London as a result of this. But it worked unbelievably efficiently. And the message that I got from that was that it worked well. And the message I would give you is that you can use these procedures, I'm not sure cumulatively, but they are certainly not mutually exclusive. Yes, certainly.
If I could comment briefly on the 2 points. Firstly, you're quite right, the 90% maybe is slightly misleading because it actually comes from CEDA, which is the Centre for Effective Dispute Resolution with its head office in London. And they do a biennial audit of mediation. They say overall approaching 90%, but the percentage actually settling on the day is decreasing to about 75%, and then they reckon about a further 15% are settling within a short period of the mediation. So if I conveyed 90% on the day, that was wrong. It's 90% overall. Also, to be frank, it's sometimes a bit difficult to define success. If you start the day with 10 issues and $10 million, someone may say you've achieved a fair measure of success, a 4-week trial, say. If you, by the end of the day, have settled 5 of those issues, and what's left can be dealt with in a trial of half that length. Clearly, it's not complete success, but it is some measure of success. But broadly, those are the figures, and that's where they come from. On the point that Sir Bernard raised, Singapore has been extremely adventurous in its offering to disputants. They have a world first. I think it's called the Singapore International Mediation Center. So Singapore's ambition is clearly to hoover up mediations, not just from the region, but perhaps from wider afield. And it's quite an interesting offering because it operates in conjunction with the SIAC, the Singapore International Arbitration Center. So I think what happens is you start an arbitration under SIAC rules. That arbitration is immediately stayed. Then a mediator is appointed under the SIMC rules. If that's successful, the mediation agreement is drawn up as a consent award and can then be enforced in all the countries party to the New York Convention. If the mediation is unsuccessful, it goes back to SIAC and runs on to an eventual arbitration award. You'll appreciate from the views I expressed earlier that that's interesting, but to my mind, not the ideal. I still think it's preferable to have the increased flexibility of the arbitrators being able to order mediation at the time that mediation is most appropriate, which won't necessarily be right after the arbitrators have been appointed.
Thank you. And can I bring in, is it Andrea Mastellone? Your experience, I think, in China, I'm particularly interested, and what Mr. Zhu said. And do you have experience? And if you have wider comments as well, then I think we would welcome them, certainly.
Yes, thank you. I have a couple of questions. First one for Mr. Zhu. My question, I do business also with the containers. So my question is, your speech was why they failed to get their awards enforced in China. My question is, why the container owners fail to recover damages from Chinese shippers responsible of misdeclaration of goods and the carriage of unlawful goods and counterfeit goods? After, I have a question for Mr. Carston. Very small.
Thank you. I have worked in Maersk Line as claims man for 10 years. I saw a lot of this sort of disputes worldwide. Many Chinese shippers, cargo, they send to the overseas Italy or South America, etc., and then abandoned. And then there's a dispute, particularly from the liner, from the shipping line. They have difficulty to take a recovery action. In my point of view, reason one is that most cases, first, is a very small dispute. Amount of dispute for container normally is $50,000 per container. So first, it's small. It's not worthwhile, the trouble. Secondly, if there is some kind of a dispute, normally, in my point of view, the shipper may be not so decent, maybe small, maybe have lower set. So it's difficult to take a recovery action. I think mostly, however, if, for example, we also acted on behalf of a liner, shipping company, take if it's a large amount, for example, 100 containers are abandoned, etc., there are disputes. For example, I remember one case is that Hanjin, their vessel exploded, and then they take recovery action. They sued against the shipper in China. Yes, so I hope it answers your question. Thank you. Yeah, thank you.
Very, very small. About how to build up an ITL clause in a charter party providing the carriage of goods subject to natural weight loss. For instance, I live in Naples, I operate in Naples. The provision of Chamber of Commerce says that in the carriage of wheat, a loss of 1% is provided as natural loss. So how to match the provision of the official provision of Chamber of Commerce with the ITL clause, which provides us maximum 0.5%? Thank you.
Well, I think all you do is you just change the percentage in the clause. I mean, the clause that we saw in the case that I put in front of you was tailored to that particular trade. Again, you've got a natural wastage that goes on because oil product does evaporate. You know, the measurements might not be the same at both ends. You may well have temperature differences. So I think all you do is just simply change the percentage in your clause, that's all. And then that would tie in with it. I think the clause would work. The clause that we saw in front of you would work in your situation, change the 0.5 to 1%. And I think that's good enough.
This is free legal advice, huh?
It's always worth the paper it's written on, Luca.
I think Per-Åge wanted to say probably something more on mediation. I think Per-Åge, we are probably involved in an alleged salvage case, quite relevant, in which the scenery, mediation, arbitration may be quite realistic. So we have something really in real time, which is, I think, without hearing our friends who are so knowledgeable about the subject, were also a good excuse to bring the jurisdiction from one jurisdiction to another jurisdiction, perhaps.
Yeah, well, I find mediation extremely efficient in circumstances like that, where also multinational companies are involved. And one follow-up question to Mr. Lux is, we've seen instances where there is a compulsory mediation. It can be a court that instigates mediation and forces the party to go ahead and do it, which, in my opinion, not always is that successful as it would be with voluntarily mediation. But I have also experienced cases where you're coming to mediation in a voluntary setting, and one party quite simply is not moving away from a position. And is there any remedy under such circumstances for mediation where you quite simply find a party who is coming to the mediation setting in bad faith? Have you any experience with that?
Yes, in England, no judge can, or arbitrator, I think, can force a party to mediate. There are some jurisdictions where mediation is compulsory, and I think that Italy is one of them. I think what happened in Italy was that a law was put through Parliament to make mediation compulsory, mandatory. The lawyers then went on strike. There was then a reference to the Constitutional Court. The Constitutional Court declared the particular law to be unlawful, but the mediation community then got their act together, prepared a better drafted law, resubmitted it to Parliament, and I'm afraid I lost touch at that point with whether it is or isn't now mandatory. Anyway, the short point is there are some jurisdictions, Argentina is another example, where mediation can be mandatory. England is not a case in point. There are all sorts of ways in which when one studies to become a mediator, you learn sort of how to optimize the chances of moving an intransigent party from just, no, this is my position, to a position where there's a real negotiation happening. It doesn't work in every case, but in the overwhelming majority, it does. which is one of the reasons the English courts are such fans, because often the party who's refusing mediation says, look, I was really sure of my position, there was just no point, no one would have been able to persuade me otherwise. And several of the judges have said, no, that's wrong. A skilled mediator has the potential to move parties away from even entrenched positions to a more flexible approach. And it's not unusual at the beginning of the mediation day that the lawyers on one or perhaps even both sides come up to me privately and say, Jonathan, we know you'll do your best, but frankly, in this case, we'll never settle. And most of them do.
Okay, thank you. I think this, I want to thank all of you, in particular Sir Bernard Eder, who chaired this session so interestingly, and I think all the contributions were very interesting.